Welcome everyone to today's presentation on Bankruptcy and Breakdown of the Marriage 201 Advanced Topics. This is part 2 of a presentation that Linda, Howard, and Golan did in October. So this will be focused on advanced topics today. We also just please ask that you keep in mind that this presentation is intended to provide you with general information in family law and should not be construed as legal advice. And now getting into our agenda. So in this 1-hour presentation, our presenters will be discussing the following topics. They'll be doing a quick recap of the presentation, as I mentioned, that we did in October. So bankruptcy and breakdown of the marriage 101. Then they'll be getting into bankruptcy and the effect on equalization, bankruptcy and support obligations, and litigation strategies and practice tips. And there'll also be a Q&A segment, a dedicated Q&A segment at the end of the presentation. So if you haven't already, please feel free to submit your questions through the Q&A box, and we'll do our best to get to your question during the presentation. So now that you know a bit more of what's on the agenda today, it's now my pleasure to introduce today's professionals that will be presenting on today's topic. So first we have Linda Stern, and Linda is a senior manager and licensed insolvency trustee at Crowe Soberman Incorporated. She has over 25 years of experience working in Montreal, Ottawa, and Toronto, primarily in consumer insolvency matters, consulting with individuals overwhelmed with debt and helping them find solutions that work best for their financial and personal situations. And next we have Howard Manis, and Howard is a partner and senior counsel at Manis Law. He has been practicing bankruptcy and insolvency law and commercial litigation since his call to the bar in 1993. He provides legal advice to trustees in bankruptcy, receivers, banks, and other financial institutions, landlords, trade suppliers, and debtors in all aspects of insolvency law, including bankruptcy, proposals, reorganizations, and restructurings, enforcement of security, and in protecting rights outside of insolvency proceedings. Next, we have Golan, and Golan is an associate family lawyer and a certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. And he has extensive experience in representing clients and negotiation agreements as well as trial work. He also has experience in negotiating with the authorities to advance a client's interests and have represented clients at various levels of court, including on appeals. Next, we have Russell, and Russell is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell offers a wealth of knowledge and expertise in collaborative family law. He uses his experience with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. And now I will pass things over to you, Russell.
Thank you so much, Shannon. Great introductions. Let's make a start. We've got a lot to cover today. So let's start off with our first poll. What happens if my client or the other spouse goes bankrupt during a family court case? So this is, this happens. And you've got a couple of options here. I'm going to give everybody a minute to go through the options. I want to let everybody in our audience know we are running polls today. Makes it a little bit more interactive. It helps us understand where our audience is at, and we can tailor our content accordingly. We have time for Q&A at the end. This program is a result of a suggestion by an audience member. We designed this program. We did 101 on this issue, which was really well received, and we had requests for more. So please give us your feedback. It helps us develop new content and helps us understand if we're making good progress in this live event series. So your options today, okay, somebody goes bankrupt during a family court case, everything stops, continue with all claims except exempt property, continue with property claims through your trustee, ask the family court to determine equalization, lift the automatic stay to continue with your family law claims, or other, which you can put in the Q&A box. Let's see what our audience thinks. Okay, everything stops. Well, 3% continue, 9% go through the trustee, 51%, fairly big a majority there. Ask the family court to determine equalization, 19%, lift the stay, 13%, and other. So Howard, what do you think of these results?
Well, I think the answer is probably a combination of three. I think first you would lift the automatic stay so you could continue with your claim in family court. or you might proceed with the property claim through the trustee. So probably if it's 83% probably got the right answer.
Yeah, you're right. Linda, thoughts?
I agree with Howard. The first thought came to my mind is lift the stay and continue the proceeding and take it from there. But all the others, the other two as well, make sense.
Yeah, and we're going to talk about this. Only the property aspect is going to be stayed, right? You got parenting, you've got other claims that the family court can still press on with, and we're going to get into that. So sometimes you might not even, why even lift the stay if there's nothing there, right? You know, you don't want to expend the money, but we'll talk about tips and strategy in a moment.
All
So
fair comments, Russell, that what has to be paramount is practicality and cost.
Right. Yeah. You know, are you going to go throw good money on legal fees? Just the result, there's going to be nothing there. You know, there's some people who do it for improper purposes, right? They want to protract the bankruptcy proceeding or cause harm to some people. So, all right, let's make a start. What are bankruptcy and consumer proposals? So what we have here is a recap. We're going to do a quick recap of our 101 material because I think you have to have a basic understanding of some of these things to understand it more in depth, which we're going to get into today. So Linda, can you take the lead on this?
Sure. Bankruptcy and consumer proposals are two debt solutions that are available to individuals through the Bankruptcy and Insolvency Act, which is a statute that is followed. A licensed insolvency trustee acts as a trustee in a bankruptcy and as an administrator in the consumer proposal, and they're filed with the Office of the Superintendent of Bankruptcy, and the trustees are supervised and licensed by the Superintendent of Bankruptcy. A bankruptcy occurs when either an individual files an assignment in bankruptcy, an application is made by a creditor to put the person in bankruptcy, and the application is granted and an order is granted, I'm sorry, where a proposal is filed pursuant to Division 1 of the Bankruptcy and Insolvency Act, and it's rejected at the meeting of creditors, the individual is automatically bankrupt. But we're speaking today on consumer proposals, not Division 1 proposals. So some quick facts on bankruptcy. There's an automatic stay of proceedings on legal actions, garnishments, and judgments. Non-exempt assets such as equity and real property, investments, tax refunds, they vest in the trustee for realization and ultimate distribution to the creditors. After acquired property such as lottery winnings or inheritance also vest in the trustee. A bankrupt cannot act as a director of a corporation and most likely has to report the bankruptcy to its professional association, example, the Law Society or RICO. A bankrupt cannot sponsor an individual. In a consumer proposal as well, there's an automatic stay of proceedings, but the assets remain vested in the debtor, not in the administrator, including after acquired property. An individual or a bankrupt whose unsecured debts are $250,000 or less, excluding mortgage, can file a consumer proposal. A formal settlement is made to creditors, which is binding. Once it's approved or amended, it's binding on all the creditors. The administrator reports to the creditors that the realization projected in the proposal is X and a bankruptcy is Y, and therefore we recommend the acceptance of the proposal. Most consumer proposals are paid over 5 years in monthly payments. They can be accelerated without interest or penalty. Credit bureaus maintain the record of the proposal for 6 years from the date of filing. In a bankruptcy, it's also 6 years from the date of discharge, from the date of discharge, or 14 years if it's a second or multiple bankruptcy.
Okay, so that's great. Thank you. Who, how, and when? Howard?
Thank you. What's of most interest to this audience today is two spouses are fighting. One ends up filing either a proposal or a bankruptcy, and that's how you find yourself in this situation and governed by the Bankruptcy and Insolvency Act. So this could happen prior to separation, post-separation. The effects are somewhat different, but timing doesn't really make a huge difference. It often happens either once there's a determination of equalization or when there's a very large cost award against one spouse. Those are the common instances which would push one spouse to file for some kind of insolvency protection, but there are various permutations and combinations that could result.
All right, we've got some great questions coming in from our audience. Thank you very much, everybody. Let's run our next poll and find out who our audience is. Tell us a little bit about yourself. You've got a number of options here. A professional in family law, bankruptcy law, different area law, another field, going through a separation or divorce, helping a friend, a student currently in bankruptcy or other. Take your time, put your answers in there. This is a good question. They're all good questions. This is one that just came in. For the purposes of impact on equalization claims, does a consumer proposal have the same effect as bankruptcy? So I guess, Linda, what do you think? Is family law action stayed if there's a consumer proposal, or does it have to be a bankruptcy? I see Howard shaking his head.
Howard, go ahead.
I'm happy to take that one. When you file for bankruptcy or a proposal, there's an automatic stay of proceedings.
Right.
So everything would be stopped, subject to the first poll question that you may want to lift the stay for certain advantages that you might be able to obtain.
So it doesn't have to be a formal bankruptcy. A consumer proposal can put the brakes on your family court case, and it's really like throwing a grenade into that litigation, right? It could really disrupt the flow of the family court case, depending on the issues that the family court's dealing with. All right, so let's take a look at our audience and find out who we have with us today. Family law professional, 64%. Somebody in the bankruptcy area of law, a different profession, 14%. Learning more, 9. Going through separation, 6. Have a loved one and helping them out. So a fairly sophisticated audience today. You're in the right spot. We're doing advanced topics. All right, let's get back to the roles of the various players. So again, sort of recapping, but it's important to understand who is it's no longer a family court proceeding. You got all these other players that are coming into this. So if you're thinking about equalization, you want to keep in mind who else comes onto the stage. Linda?
So thank you, Russ. The trustee is an officer of the court and has a fiduciary capacity for the creditors, acts in a fiduciary capacity. The primary role is to balance the interests of the bankrupt and the creditors. So the main areas of responsibility is to meet with the individual to get an understanding of their financial situation and provide them with the merits and consequences of each option. Once the option is chosen, prepare documents to effect the filing, file the documents. If there's need for a creditors meeting, the trustee convenes one. The creditors file proofs of claim indicating what they're owing, with backup. Trustee needs to review those claims, usually if there's going to be a distribution to the creditors, and then relies on the non-exempt assets for the benefit of the creditors, and subsequently apply for the bankrupt's discharge. So those are the main functions of a trustee. The creditors are classified into secured, preferred, unsecured, and contingent creditors. So secured creditors hold mortgages on real property, leases or finance agreements, usually on vehicles, general security agreements on assets, and in this situation would be a sole proprietor. We're not speaking corporation.
It sounds like, you're in the airport waiting to go on the plane, and then you have, the different classes of people coming to go on the plane, you know, Delta Elite, your triple platinum, your first class, you know, your zone 2, zone 3, and then, you know, zone 5 is down at the back of the plane where the bathroom is. It sounds like you have a hierarchy of credit,
Well,
right?
it's a good analogy, Russell, and in many situations you have CRA with the priority who's going to be sitting right behind the pilots.
Yeah, or
So,
they
you
are
know,
the pilot, really.
They are the pilot, yeah.
I think the overriding point is you don't want to be any class of creditor.
Right. What else is there?
No, you prefer not to be in a bankruptcy situation.
Yeah. No, I get it.
It's not a good position.
All right. Well, we've got clients here now in family court who are going bankrupt, but yeah, we can't control that part of it. You're right.
Right.
Good point. Sorry, go ahead, Linda. I didn't mean to interrupt, but I thought it was a good
No,
announcement.
it was a good interruption, Russell. It's a good interruption. So continuing with secured creditors, you have PPSA registration for storage, liens, and repairs, and of course the CRA with registered certificates on real property. So should there be no equity for the creditors, in particular a matrimonial home or a financed vehicle, the trustee generally releases its interest and the bankrupt continues with the payments in the normal course. Should the bankrupt wish to surrender the security, then the creditor has the right to file an unsecured claim for a shortfall, which in many cases, in particular vehicles, there will be a shortfall. Preferred creditors are governed by Section 136 of the Bankruptcy and Insolvency Act. So in this particular discussion today, child and spousal support arrears are preferred creditors for amounts owing or any lump sum owing 12 months prior to the filing of the bankruptcy. To the extent that there's funds available, preferred creditors after trustees' fees and costs are paid in full before unsecured creditors. So generally,
do they go before CRA or after?
If CRA has a claim for income tax or HST, they go before.
Okay.
If there's a payroll for sole proprietor, if there's source deductions that have not been remitted, then they're a deemed trust creditor and they rank ahead of trustee fees and costs as well.
Okay. Thank you. Go ahead.
Yeah. So unsecured creditors would include child and support, spousal support arrears, where their preferred status is already been met and there's a balance owing. So 30,000, 15 is preferred, 15 is unsecured. Equalization claims, which Howard will speak on, costs awarded in a matrimonial proceeding of the spouse who has the obligation to pay those costs. So those are unsecured, but I believe Golan or Howard will be speaking to that after. Legal costs, income tax and HST for sole proprietors, bank loans, lines of credit, credit cards, student loans, judgment creditors. These are all examples of unsecured creditors. Should there be a meeting of creditors, there could be up to 5 inspectors appointed, and creditors can act as an inspector. And the primary role is to approve the sale of assets and the disposition of the bankrupt's discharge. Those are the two main functions that we see. Contingent creditors are claims that may or may not crystallize in the period of the bankruptcy, such as legal actions not heard by a court, assessment of a director for unpaid corporate taxes being payroll and HST, not corporate tax liabilities, unliquidated damages. So depending on the nature of the claim, a trustee may, not often, but may value the claim or agree to have the creditor lift the stay to continue the proceedings. And assessments against directors are always out there, but it's a process for CRA, and especially now, we're seeing that it's a long process and they're not assessing as often as they did pre-COVID.
lot to take in there.
Lots to take in.
Thank you. Let's talk a little bit about judges, the family court, and bankruptcy court. Howard? These
All
are
right.
other players we need to be mindful of, right?
Yeah, and I'll be brief. We generally find disputes start in family court between the spouses. And then when one spouse goes bankrupt or files a proposal, everything, as we said earlier, stops because of the stay of proceedings. So then there would be a motion, presumably in bankruptcy court, to lift the stay. And the most common reason would be to determine what the value of equalization is so that we can file a claim within the bankruptcy. So that's the most common, but the attendances in bankruptcy court should be one and done.
My understanding, correct me if I'm wrong, every superior court judge is also a judge of the bankruptcy court. But the bankruptcy court is a different court, usually in Toronto or Ottawa. They're different locations. Not where are these bankruptcy courts?
Well, pre-COVID, we had bankruptcy court in downtown Toronto, which covered a wide jurisdiction, both north, east, and west of Ontario. They've since added a bankruptcy court in Hamilton. There's a bankruptcy court in London, and I believe there's a bankruptcy court in Sudbury.
So depending on where your client is, if you're up north or somewhere, you're going to have to hike it down to Toronto to go to bankruptcy court, which is going to increase expense, obviously.
Right.
And it's a specialized court with specialized forms and rules, right?
Right. So COVID virtual court assists with that problem.
Yeah. Access to justice.
Access to justice, because you don't have to go anywhere.
Great point. And it's super prejudicial if you have to pay your lawyer 4 hours to go to a bankruptcy court because the other party went bankrupt. Some real unfairness there.
Right.
Okay, so conflicts. We have protecting third-party creditors and rights of spouses. I think we're going to have you take this one too, Howard.
Thank you. So the obvious conflict that is inherent in the system is a bankrupt person or a debtor goes and chooses a trustee, pays the trustee for their services. They sign on the dotted line, and then the trustee represents the best interests of the creditors. So the inherent problem is the debtor comes to the trustee, lays out their whole story, tells them all the warts and blemishes and secrets, and then the trustee uses it against them. It's not the trustee's fault. It's not something that we have to, govern the trustees. It's inherent in the system, but it's an obvious conflict. So I guess the easy way, but not costly way to address that is if the debtor gets some legal advice before going to a trustee. What I've often seen as well is someone goes to a trustee, tells them their story. The trustee tells them, well, you're going to have all these problems. So then they go to a different trustee and they refine their story so that second trustee doesn't know the problem.
Start shopping around, yeah.
Right. Find someone who's going to give you the answer you want.
And it's sad, you see these people who go into bankruptcy. They may have a very good equalization claim, and they're just kind of shooting themselves in the foot. But oftentimes they do it because they can't fund family law litigation and they just get overwhelmed.
That's correct. And then the trustee in a perfect world would pursue the equalization claim for the benefit of the creditor.
But we were talking before, if this is a joint family venture claim, trustees aren't equipped to necessarily litigate those issues. Family lawyers have problems doing that. So it really is, a dark hole they're going into. But let's find out what our audience is thinking and run another poll. Thank you for that, Howard. All right, what happens to and we base these poll questions sort of on what our clients are asking us, right? Or what they're asking their trustee. So this one is, what happens to the matrimonial home if one spouse goes bankrupt? Give everybody a few moments to give us their input. Some great Great questions coming in. Thank you, everybody, for sending your questions in. This one's for you, Linda. Child and spousal support are child and spousal support preferred creditors and rank ahead of mortgages lines of credit?
Mortgages would rank ahead in the sense that if there's a sale of a home, the mortgage is getting paid from the home and the residual comes into the bankruptcy estate for realization. So it's a really it's a function of what realization comes into the estate, and the support as a preferred claim would benefit mostly from that portion.
Right. One more quick question. Thank you. Keep them coming in, audience. Maybe I'll throw this one at you, Golan. How does a lawyer or mediator actually do the NFP with a bankruptcy in place? How do they navigate this? This can get complicated.
Thank you for the question, Russ. And just before I answer that, just a comment on the access to justice comment before. I wish that would be expanded to the family proceedings as well. I think that was a topic of concern to all of us during and after COVID. But straight to the question again, on the equalization process, it's practically the same way as if there was no bankruptcy, because you have to determine if you're going for example, after an exempt asset at some point in time, you still need to determine what is the equalization amount. So you have to go through the NFP, through the net family property statements, and the value of the assets just the same. So you have a determination of the equalization before you can go back to court and ask for the relief that you're looking for.
And this is one of our advanced topics. We're going to actually, it's timely, we're going to get into this just in a moment, but so we've got what's going to happen to the home. Other spouse gets it sold, trustee takes it, non-bankrupt spouse. Our poll results are coming up right now. The other spouse gets the home 0%. Well, maybe not. See what everybody thinks. The home sold 18%, trustee takes possession 22%. Non-bankrupt spouse makes a deal with the trustee 50%, or other. Yeah, I think certainly that's the most practical approach, right? Howard, to make the deal with the trustee to deal with whatever equity might be there.
That's the most practical solution, but it's not always possible because the non-bankrupt spouse doesn't have $100,000 with which to make a deal with the trustee. There are a variety of reasons and different solutions, but that's the primary one. The other one often is have the trustee register on title, and it would only go against the bankrupt spouse's share of the home. But not all trustees want to do that because their job is to realize as quickly as possible.
So that's sort of an if and when. So if the home's refinanced or sold, then they would get their claim?
That's correct.
For those deals, it's a really interesting solution. Is there a time limit, or can it just be, okay, I'll pay it in 20 years?
Well, the trustee doesn't really want to wait 20 years, but it happens sometimes. I've just had 2 of those recently, where the trustee waited many years.
And the housing market appears to be taking a dip. What if they're upside down on the home? Is the trustee going to be more likely to make a deal? Like let's say
It's all based on the equity. Exactly.
Yeah, let's say it's financed for more than the home's worth. We're seeing property values drop. Would the trustee then be more likely inclined to make a deal with the other spouse?
In those situations, the trustee would probably just release its interest.
Right. There's nothing there. Yeah.
Nothing there.
Yeah.
I'll add to that.
Pay $1,000 for me to do the paperwork to release my interest.
Yeah, right. Sorry, Linda, go ahead.
I can add to that. If the discharge of the bankrupt is delayed for CRA oppositions or documentation that the trustee requires, and we're suddenly 5 years down the road, the property may increase in value due to market or mortgage repayment. So that equities now become an after acquired asset. And the trustee can do a valuation and add that in to the conditional discharge order, or go to the spouse to make a settlement with her.
Or if you're making the deal with the trustee, say your interest is capped at 100 grand. So if it goes up, to 300,000, they're only going to get the first 100. But Golan, you want to get in on this conversation too?
Well, I thought the policy actually presupposes that the property is in the name of the bankrupt. Am I correct? And that's otherwise, that's the first determination that has to be made here. Who's the legal owner of the property? And then you have to see what is the other spouse is doing. Is there a property claim in equity? Is there claims that may be affected, in terms of constructive trust, resulting trust, etc. That the other non-registered spouse may want to bring to the table, and then go with that to the trustee for negotiation.
Well,
So
if it wasn't that spouse's name, it's a matrimonial home, it'd be up to trustee to pursue the equalization payment at that point. But yeah, it's an interesting spin on that. So let's get into bankruptcy and the effect on equalization. Thank you for everybody for participating in the poll. We've got a lot that we're going to cover off here, and we're a little bit behind, but I think we're good on time, and we want to save time for Q&A. Please keep your questions coming in. So exempt assets, I think, Howard, we're back to you on this.
Thanks. The two most significant exempt assets, the first being RSPs. So RRSPs are exempt except for contributions made in the last 12 months prior to bankruptcy. So if the bankrupt spouse has $100,000 of RSPs and made no contributions in the last 12 months, then that $100,000 is outside of bankruptcy and not available for the trustee or to the creditors. So that was a legislative change made a couple of years ago and designed to assist people who save for their retirement to still be able to save for their retirement. The other common exempt asset is personal injury awards, because a lot of times people go bankrupt after having a car accident and can't work for a while. So it's not all awards, it's only the portion that's attributed to pain and suffering. Anything related to lost income would fall to the trustee. So you often have personal injury lawyers trying to settle cases saying that it's all pain and suffering. And you have the trustee saying, well, it can't all be pain and suffering. So you get into that conundrum.
That would be excluded in the family proceeding in any event if it was pain and suffering, right?
I believe so, but again, it's the determination of the total amount of the settlement all being pain and suffering, so it's exempt all over the place.
And Golan and I are going to talk a little bit about strategy in terms of what assets you're going to choose to go after, but thank you.
The last point, Russ, in 10 seconds is that RESPs, registered education savings plans, are not exempt. So that's important to know.
Yeah, I wouldn't think that. Okay. Claims that survive discharge, Linda?
Child and spousal support arrears are the main one that survive. Student loans, if the individual's end of study period is within the last 7 years. Court-imposed fines, such as parking tickets, traffic parking tickets, debts arising out of fraud, and one that we're seeing, Howard and I have seen recently, a liability for a dividend that a creditor would have received had the creditor been informed of the bankruptcy. So you do have debtors that choose to not disclose a loan to a friend, family, business partner, and there's a dividend paid out of 20 cents on the dollar, and the individual would have received 20 grand, let's just say, that is not wiped out from bankruptcy if they were not aware of the insolvency.
All right.
So these debts are considered Section 178 debts, and they're pursued by creditors after the discharge of the bankrupt and after the discharge of the trustee.
Is that common?
It's common.
Yes.
Okay.
It's common, yes.
If the facts are there, it is common.
Yeah,
Yes.
okay. Assignment of claims, Howard.
So the most common one here would be where a joint debt between spouses, one spouse files for bankruptcy, the other one gets a letter from the bank saying the co-spouse or the co-debtor went bankrupt. You now owe the whole amount owing on the credit card. In this case, the non-bankrupt spouse might make a settlement with the bank and then take an assignment of their claim so that they can hope to recover that back within the bankruptcy if there's any realizations. The simple answer is sometimes people make deals with creditors and take over their claims only for strategic reasons. It doesn't happen often.
Okay, judicial discretion, Golan. Is there any wiggle room for judges here? Like the bankruptcy has a pretty comprehensive regime. Can the judges play around here or what's happening?
Well, so that was in some of the case law, when you go through it, you see that when judges had the sense of a injustice that occurred, and they try to do something different or basically circumvent the Bankruptcy Act, on appeal they were reversed, and it was just basically telling us that that's the law and that's what you have to follow, and we cannot go around it. Now, in other occasions, you find that there are creative ways of making or making justice happen somehow through support claims and the quantum of the same. Other discretion that is actually supported by case law is what happens on bankruptcy that happened just before, just at the beginning of the marriage. So if a person came with a lot of debt into the marriage and then went bankrupt during the marriage and got discharged, normally you would think on an equalization, it would actually negate his portion for equalization because he came in or she came in with debt. But because of the bankruptcy, and these debts were wiped, a judge has a discretion to not necessarily put in the face value of the debts that a person came into the marriage with. So that discretion is there with respect to bankruptcy and the equalization process.
All right, like Shannon's in the background keeping tabs on me. I missed the poll question, so we're going to run the poll right now. Sorry about that. How are loans from friends and family treated in bankruptcy? Right, these are questions we get. The lawyer's going to get it. The trustee's going to get it. Give everybody a chance to answer that. And I had some really great questions coming in. There was a question here. Does the percentage ownership of the home come into play? So if a spouse goes bankrupt, let's say they're on title, they're only registered to be 25% owner. Is the trustee going to honor that percentage or what, Linda?
If the documentation proves that it's owned 25%, it's registered on title showing 25%, and the purchase and sale agreement is 25%,
Right.
then it will be honored.
Yeah, you sometimes see that, right? Parents will go on title for financing and other reasons. So
I have a young gentleman now who holds 1% on the condo. It's basically for mortgage purposes.
it's exactly right. Yeah.
Yeah.
Great question. Okay. Loans from friends and family, they get paid first, last, creditors, they lose their loan and their friendship. Get paid cash, I guess, down at the gas station or the ATM. So our audience, they get paid last 12%. They're listed as creditors, secured or unsecured, 78%, clear majority. They lose their loans and probably their friendship, 10%. Real quick, Linda, what happens to friends and family in this process? What are you seeing?
They should be listed as creditors. And
are they though, or they just give up?
it's a 50-50 situation, and we also see that they're paid back through the bankruptcy because of the, responsibility, the feeling of I can't not pay my friends and aunts, and we're seeing that.
Thanksgiving dinners is too awkward. I'm going to pay this person back kind of thing.
It
Well,
becomes a
it's-
Christmas gift, no?
That's right, but that's outside the scope of bankruptcy, and
Right.
it changes from the fact that all creditors are supposed to be treated equally.
Right. Right.
So the one thing they can do is unfriend a friend.
Right.
That's one of the, right?
Unlike them, yeah.
I guess family you don't have an option with, but things happen there.
You know, it's funny, but it's so sad because these are real life situations that our clients are going through, right? Like it's heartbreaking when you see this.
They borrowed from relatives, and the relatives are not sitting with a lot of assets, and they feel the obligation. They help them. They feel the obligation to pay them back. It from that point of view, it's understandable.
Yeah. All right. Let's get back into our subject matter. That's a great poll question. Bankruptcy before or after the date of separation? Golan, does it matter?
Yeah, it does matter. It matters. It depends on which side of the fence you.
Whether
Is
you're
that-
the spouse or the bankrupt, right?
Right. Yeah. So if you're a spouse that goes bankrupt before separation, you're giving up you're basically vesting your claims in property with the trustee the moment you claim the bankruptcy, right? And that means that you may be losing on your option to realize on your equalization. When you're doing it after, depending on, again, which side of the fence you're representing, you may be trying to get away from a cost award, and it may be the right thing to do, subject to judicial intervention and lifting automatic stays. But it does make a difference whether you're doing it before or after. I think the best thing to do here is definitely consult before you make the decision to go back on. That's for sure.
Yeah, you think of a cost awards usually prevented from taking further steps in litigation unless it's been satisfied or paid. And I guess, well, I wiped it out in bankruptcy, so now I'm going to resume my litigation. But yeah, I don't know if that'd go over too good with the Superior Court judge. Effective discharge. What do we need to know on this one?
So am I taking that? Or
Yeah,
is that
you're still going if you can.
Yeah, sure. Well, the effective discharge, essentially, we're speaking about, let's say, the first-time bankruptcy. We have the automatic discharge within 9 months, wipes out all the claims other than the claims that are a surviving bankruptcy that were mentioned before, including the support claims. So yeah, it basically allows the bankrupt to start fresh in generally, but on other occasion when you think that it's warranted, the other side or creditor or a third party may present an objection and oppose the discharge, and that can be extended to 21 months, I believe, right, Howard?
That's correct.
Opposing discharge. That's interesting. Can you think of a reason why a spouse would want to oppose discharge, Howard?
Spouses often oppose discharges for two reasons. One, out of spite,
Yeah,
and another because they either think that the bankrupt has undisclosed assets or undisclosed income. Although I would say that you don't need to wait for the discharge to deal with that. If that's really the case, bring it to the attention of the trustee early on and have that matter dealt with through the bankruptcy process and not wait till the end. But a lot of times it's out of spite.
usually the ones out of spite fizzle off too, right? They run out of steam or they're not going to throw any more money at it. So
Right.
it's sort of a knee-jerk reaction. They usually just kind of fade away after a while.
That's true, but you'd be surprised how many spouses show up in court unrepresented and just take their shot.
It must be tough on the bankruptcy court too, right?
It is.
Yeah.
Dealing with unrepresented people who don't know the process.
Or the act. Yeah.
Right.
All right.
I'll
so-
also add to that, that the spouse, like any other creditor, is hoping that the court will grant a conditional discharge, and the more funds that the bankrupt has to pay to be discharged is a greater dividend to the creditors, including the spouse.
Sure.
So that,
So
you know,
there, it does serve a purpose.
it serves a purpose.
Bankruptcy and support obligations. I know in family court, child support takes priority. What are we looking at for child support? Do you want to lead the discussion off, Linda or Howard? Who wants to start with this one?
Howard,
Yeah, child support and spousal support, as Linda said, survive bankruptcy. They also come into play in the calculation of surplus income for the bankrupt person, and surplus income is a whole other kettle of fish that we don't have time for. But in 30 seconds, if the bankrupt person is earning more money after tax than the government standard, depending on the size of the family, then a portion of that money gets paid to the trustee for the benefit of the creditors. But if the bankrupt person is paying spousal or child support, that amount is deducted as a non-discretionary expense from the calculation of surplusing. I could talk about this for hours, but we don't have time for that.
We could spend for each one of these headings probably an hour in each one.
Right.
But again, we want to try to cover as much as we can. That was really helpful. Okay, litigation strategies and practice tips. So we're going to start with cost order, going after exempt assets, finish this off, and then go into Q&A. So Howard, costs.
Okay, so I've seen some cases, remote cases, where they lift the stay to allow someone to pursue cost order. I think that that's, remote. The norm is that cost orders are unsecured claims that fall within the bankruptcy. So again, as I said earlier, often you have court award a very large cost award against someone, and then they go see a trustee because they can't pay $150,000 cost award. And I think that's the norm, where those are included in the Bankruptcy Act. Collecting costs when someone goes bankrupt, not likely, because it's simply an unsecured claim. Now, as far as costs as support, I've seen that in family courts where they sometimes make costs considered to be or treated as support, which would help in the event that they think that someone may go bankrupt, because then it would survive. And I think the best strategy, if that's what the family law lawyers are thinking, is when the judge makes a cost award to say that 50% of the costs were incurred to pursue the child or spousal support.
Yeah.
So that would be very clear as to what portion would survive. But absent that, it's very hard to make them survive.
Yeah. My experience is, especially, costs are often characterized as supportive. It's related to a support issue. That's an effective way to send it off to the Family Responsibility Office and let them worry about collecting it, in terms of how do you find the money. So let's get into, you covered a lot there. Thanks, Howard. Going after exempt assets. So I'm going to talk about this a little bit, and Golan's going to help me. Having a family lawyer talking about bankruptcy law is sort of like going bungee jumping without a rope. So everybody's going to correct me, but if I get this right, you've got these claims that Linda listed that will survive the bankruptcy, and obviously one of the biggest ones, the pension. Some pensions are excluded. You can go after it for equalization, but you need an order. You need to get your order before the bankrupt's discharged. And generally, my understanding is the courts generally will lift the automatic stay to allow spouses to go after these exempt assets. And if Section 81(5) of the Bankruptcy Act requires litigation in bankruptcy court unless you get the leave to proceed in family court. So in terms of a practical tip, my tip would be hire somebody like Howard or a lawyer in whatever city the bankruptcy court is and have them do it. They're there every day. It's sufficient. They know the rules. They know the judges, as opposed to traveling down in traffic to Toronto for a day and waiting in bankruptcy court. And it's probably going to be $3 or $5 grand just to take that step. I would delegate it to somebody local, but what's your strategy here, Golan? Do you agree with that?
Well, firstly, I think you covered it pretty well. The only thing on Section 81, sub 5 of the Bankruptcy Act, I think that the idea there is that anything to do with the bankruptcy is dealt with the bankruptcy court unless that court gives you permission or grant you leave to proceed with a claim in a family court. So that's the reason that one of the strategies regarding property claims would be to advance all the equity claims against the property in the family court, and then ask for that to be proceeded in family court, but getting the leave from the bankruptcy court. On the exemption of assets, yeah, pension is the one of the most popular ones that you want to go after, but let's not forget again that before you go against the pension asset, you have to go and equalize, do the calculation for equalization just as if there was no bankruptcy. So this is where you know how much you're claiming from the pension. You cannot just simply go and equalize just the pension as a 50-50 kind of asset. You still have to go through the equalization process.
That'd be a reason to oppose the discharge. If I understood, Linda, you have 9 months. You might not be able to litigate and determine equalization in the family court in 9 months. You're not going to get to trial till a year or two later. So I guess that would be a reason to oppose the discharge. Is that right, Linda?
Well, the 9 months is where there's no surplus income.
Right.
There's no, so if there's surplus, it's 21 months. And certainly if there's a benefit to the creditors, then the discharge, if it's 9 months, it would be opposed to allow the proceedings to continue so that the creditors can maybe realize on.
We're talking a spouse going after an exempt asset, right? So the creditors aren't going to get any of that in any event. Do you agree, Howard?
Correct.
I agree.
You want to get
As
that
Golan
number.
said, you go after the pensions, and that doesn't really involve the estate because it's exempt anyways.
Get that equalization number before the discharge. If the discharge is coming up, then you would oppose it, right?
Yes,
That'd be a pretty good
be a
reason.
legitimate reason to oppose.
Right. Because the family court doesn't have the resources or time to adjudicate the matter in 9 months. Or you might be waiting on a pension valuation. It could be a number of reasons why there's delay.
Like you said, the key is to do this before the discharge. Otherwise, basically everything is
So we've talked about support and characterizing it. One last quick topic, then we're going to get into Q&A. How does the lawyer for the bankrupt get paid? Okay, one more poll. This is great. Cash, legal aid, friends, credit card, payday loans, GoFundMe, or other. So give the audience a moment to get their answers in. Linda, if somebody goes bankrupt, are the credit cards and line of credits cut off?
Yes, they are.
So, you know, that person's really limited in terms of how they're going to access legal counsel, right? For the family court.
Generally, family will help them out for if they need representation. Often we see family helping out.
Okay. Let's see what our audience thinks on this question. You look at that, family and friends. They agree with you. Legal aid, 18%, cash, 18. The lawyers getting the envelope of cash in the parking lot there. GoFundMe, 3%. There, we'll get in the Q&A. Okay, so
I would just add one thing.
Yeah.
The debtor, the bankrupt, now is no longer paying credit cards, is no longer paying for all the bills that are in the bankruptcy, but yet they still have their income.
Okay.
So they have their income and they don't have all these expenses. So they actually do have money.
they're in a better spot to pay.
That's right.
Right. So
Unless they're paying back aunts and other friends, Howard.
We have one
Yeah.
of those, yes.
they got Thanksgiving coming up. They got to get those loans paid off. All right. So for counsel, what should lawyers be mindful of? If you're representing a bankrupt in a family court proceeding, how do you protect your account, Howard? Quick practice tip, maybe 30 seconds or less.
The greatest thing is get retainers somehow. Now, there was a question in the Q&A about what happens if you have money in your trust account on the date of bankruptcy. The legal answer is that money is being held in trust for the bankrupt, so it should go to the trustee. Most trustees don't really insist upon money from lawyers' trust accounts because everybody's entitled to a representation, but legally speaking, it vests in the trustee. From a practical standpoint, the answer might be to have the person's brother, mother, sister pay the retainer. Again, practically speaking, who knows where the money actually comes from, but the check or the e-transfer goes from somebody other than the bankrupt so that the argument can be made it's not the bankrupt's money.
I always wonder about that, right? You get the list of the bankrupt's affairs and you're in family court and the other family lawyer is not listed there, right? There's no debt sold to that person. You think, what's going on here, right? But Shannon's back. I'm going to get in trouble because we've been having too much fun here. But welcome back, Shannon. We started a minute late because I was going on about the soundtrack. So we will go to 101. We're never late, but I started late. I'll take ownership of that.
No, it's a good sign. It's a good discussion happening. So just want to thank all of our panelists, Linda, Howard, Golan, and Russell, for being here for the discussion today, and to all of our audience members for all of your participation. I just want to make a quick note that there will be a survey that pops up in your browser following the webinar. And this is really great for us just to get some insight into our audience and get your feedback as we continue to progress and grow our virtual event series. And just a sign of our appreciation to everyone who fills out that survey, we'll be providing an ebook that will be sent later on. But we want to at least get another question in before we sign off today. I know a lot have been answered throughout, but just one that came in advance. So does a claim for equalization of a spouse's pension survive the discharge of both spouses? In this particular scenario, bankruptcies and discharges for both spouses occurred after the date of separation and before any claim was started.
Howard, thoughts?
I would say that, the first answer is equalization falls within the bankruptcy and is discharged upon the discharge of the bankrupt, period, full stop. However, if the family court has determined that one spouse gets 46% of the other spouse's pension, that would survive. But if it's determined through the equalization process, that would be gone. I'm wondering if you could then go to family court and have it reclassified. That I don't know.
Wow.
Interesting.
A lot to cover off. So complicated.
Well, thank you very much for clarifying that, Howard. And thank you again to all of our panelists, all of our audience today. We want to thank you once again. And as always, we welcome and appreciate your feedback, as I mentioned, through that survey, but also feel free to reach out to me at shannon@russellalexander.com with any feedback for our team. And so we just want to thank you once again and wishing you all a great day.
Thank you, Howard. Thank you, Linda. Thank you, Golan. That was hugely informative.
Thank you for having us.
Thanks so much, everyone.
Have a good afternoon, everybody. Thanks for the audience participation and poll questions.
Absolutely.